The sovereign citizen movement, also SovCit movement or SovCits, is a loose grouping of litigants, activists, tax protesters, financial scheme promoters, and conspiracy theorists who claim to be answerable only to their particular interpretations of the common law, and believe that they are, therefore not subject to any government statutes or proceedings unless they consent to them. The movement, which appeared in the early 1970s, is American in origin and exists primarily in the United States, though it has expanded to other countries. The Freemen on the Land movement, an offshoot of the sovereign citizen movement with similar doctrines, emerged during the 2000s in Canada before spreading to other Commonwealth countries. In the United States, the Federal Bureau of Investigation, FBI, describes sovereign citizens as anti-government extremists who believe that even though they physically reside in this country, they are separate or sovereign from the United States. The sovereign citizen phenomenon is one of the main contemporary sources of pseudolaw. Adherents to its ideology believe that courts have no actual jurisdiction over people and that the use of certain procedures, such as writing specific phrases on bills they do not want to pay, and loopholes can make one immune from government laws, and loopholes can make one immune from government laws and regulations. They also regard most forms of taxation as illegitimate. Sovereign citizen arguments have no basis in law and have never been successful in courts. The movement may appeal to people facing financial or legal difficulties or wishing to resist perceived government oppression and looking for a mechanism that will solve their problems. As a result, it has grown significantly during times of economic or social crisis. Most schemes promoted by sovereign citizens involve means to avoid taxes, ignore laws, eliminate debts, or extract money from the government. American participants in the movement claim that the United States federal government is illegitimate. They argue the concept of individual sovereignty in opposition to the idea of federal citizens who, they say, have unknowingly forfeited their rights by accepting some aspect of federal law. Their foreign analogs hold similar beliefs about the government of their own countries. The movement can be traced back to American far-right groups like the Posse Comitatus and the constitutionalist wing of the militia movement. But while the sovereign citizen movement was originally associated with white supremacism and anti-Semitism, it now includes people of various ethnicities. The latter sometimes belong to self-declared Moorish sects. The majority of sovereign citizens are not violent, and many will use pseudolegal tactics in attempts to ignore certain rules to get out of debt or to avoid such things as paying license fees and traffic tickets. However, the methods advocated by the movement are illegal and warrant prosecution. Sovereign citizens notably adhere to the fraudulent schemes promoted by the Redemption of Foreign movement. Many sovereign citizens have been found guilty of offenses such as tax evasion, hostile possession, forgery, threat against public officials, bank fraud, or check fraud, as well as various degrees of traffic violations. Two of the most important crackdowns by U.S. authorities on sovereign citizen organizations have been the 1996 case of the Montana Freemen and the 2018 sentencing of Judge Bruce Doucette and his associates. Also, because some have engaged in armed confrontations with law enforcement, the FBI classifies sovereign citizen extremists as domestic terrorists. Terry Nichols, one of the perpetrators of the 1995 Oklahoma City bombing, subscribed to a variation of sovereign citizen ideology. In surveys conducted in 2014 and 2015, representatives of U.S. law enforcement ranked the risk of terrorism from the sovereign citizen movement higher than the risk from any other group, including Islamic extremists, militias, racist skinheads, neo-Nazis, and radical environmentalists. The New South Wales Police Force in Australia has also identified sovereign citizens as a potential terrorist threat. The sovereign citizen movement comes from the crossroads of the modern American tax protester phenomenon of the radical and racist anti-government movements in the 1960s and 1970s, and of pseudolaw, which has existed in the United States since at least the 1950s. The belief in the illegitimacy of federal income tax gradually expanded to challenge the legitimacy of the government itself. The concept of a sovereign citizen whose rights are being unfairly denied originated in 1970, one in the Posse Comitatus movement as a teaching of Christian identity minister William Potter Gale. The early form of the movement was thus strongly associated with white supremacist and anti-Semitic ideology. The Posse Comitatus was a far-right anti-government movement that denounced the income tax debt-based currency and debt collection as tools of Jewish control over the United States. After originating in that particular group, the sovereign citizen concept went on to influence the broader tax protester and Christian patriot movement. The concepts of the redemption movement, which appeared within a successor organization of the Posse Comitatus, became a part of sovereign citizen ideology. The sovereign citizen movement garnered more support during the American farm crisis of the late 1970s and 1980s, and a financial crisis in the 1980s and a financial crisis in both the U.S. and Canada during the same period. The 1980s farm crisis saw the rise of anti-government protesters selling fraudulent debt relief programs, some of whom were associated with far-right groups. Those activists included Roger Elvick, who conceived the redemption methods. Later on, the advent of the internet facilitated communications between people sharing the same ideas and helped the movement branch into other countries. One influential American guru who helped spread sovereign citizen ideology abroad was Winston Shroot, who held seminars in Canada until he was prohibited from entering the country. Australia, New Zealand, and the United Kingdom. Over time, the movement expanded beyond its original white nationalist environment and appealed to people of all backgrounds. As of the 1990s, sovereign arguments have been adopted by minority groupings, notably the African-American Moorish sovereigns, the movement's white supremacist origins notwithstanding. The Moorish sovereigns' beliefs derive, in part, from the Moorish Science Temple of America, which has condemned this sovereign citizen offshoot. Since the 1990s, the number of African-American sovereign citizens has increased substantially. Various groups have appeared, some Islamic in nature, others adhering to New Age philosophies. Sovereign citizen ideas have also been adopted by some groups within the Hawaiian sovereignty movement. Sovereign citizen tactics have been used by members of various other fringe political or religious groups, such as black separatists, or the Fundamentalist Church of Jesus Christ of Latter-day Saints following the 1995 Oklahoma City bombing, of which one perpetrator adhered to sovereign citizen ideology. Federal law enforcement began cracking down on white supremacist groups. One highly publicized incident was the 1996 Montana Freemen standoff. The Montana Freemen were Christian patriot sovereign citizens and direct ideological descendants of the Posse Comitatus committee. The bombing also led Congress to pass the Anti-Terrorism and Effective Death Penalty Act of 1996, enhancing sentences for certain terrorism-related offenses. American pseudolaw matured around 1999-2000, and at that point was hosted by the sovereign citizen movement. Notably, the Strawman theory was conceived around that time by Roger Elvick. During the same period, sovereign citizen ideology was introduced into Canada and then gradually into other countries. Incidents such as the 2003 Abibo standoff, the 2007 Edward and Elaine Brown standoff, the 2010 West Memphis police shootings, the 2014 Bundy standoff, the 2016 Malheur Refuge occupation, also involving the Bundy family, the 2016 Baton Rouge police shootings, or the 2020 Wakefield standoff involving African-American Moorish sovereign citizens have attracted significant media attention in the United States. Since the late 2000s, the sovereign citizen movement has significantly expanded in the United States due to the Great Recession and more specifically to the mortgage crisis. In 2010, the Southern Poverty Law Center, SPLC, estimated that approximately 100,000 Americans were hardcore sovereign believers, with another 200,000 just starting out by testing sovereign techniques for resisting everything from speeding tickets to drug charges. According to another SPLC estimate, the number of sovereign citizen influenced militia groups increased dramatically in the United States between 2008 and 2011, surging from 149 to 1274. In Canada, sovereign citizen beliefs overlap with those of the local freemen on the land movement, there is overlap between the sovereign citizen and quantum movement. A sovereign citizen group known as the Oath Enforcers attracted quantum and Donald Trump supporters into the movement following the 2020 storming of the United States Capitol. In 2022, the Anti-Defamation League reported that the sovereign citizen movement was attracting a growing number of quantum adherents whose belief in the illegitimacy of the Biden administration is compatible with the sovereign citizens' broader anti-government views. The behavior of sovereign citizens during traffic stops, in courtrooms, and in other public places is documented by many online videos that generally end in defeat for them. This has led some members of the public to consider sovereign citizens a source of amusement. Christine Sarteshi has commented that this may also cause people to underestimate the movement's potential for violence, as well as its links with criminal conduct. Several people charged with crimes such as murder or sexual assault have used sovereign citizen arguments as attempts to negate the court's jurisdiction over them. Hundreds, if not thousands, of sovereign citizens have been imprisoned as a result of their action. Many have continued their activities behind bars, often spreading their ideologies among other inmates. As of the 1990s, several hundreds of people involved in common law court, operated by sovereign citizens, or more broadly, by the patriot movement, have been arrested for crimes such as fraud, faking legal processes, impersonating, intimidating, or threatening officials, or even, in some cases, violent attack. In 1998, a number of states passed legislation outlawing the activities of these courts or strengthening existing sanctions following incidents like the 2010 West Memphis police shootings. Law enforcement agencies have provided advice to officers on how to deal with sovereign citizens at traffic stops and elsewhere to prevent their courts from being burdened by frivolous litigation. Some states have heightened penalties inflicted upon people who file baseless motions. Some courts choose to impose pre-filing injunctions against certain pro se serial litigants in order to preclude them from filing new lawsuits or documents without prior leave. The COVID-19 pandemic has increased the spread of the movement in the United States and in other countries as sovereign citizens have associated with anti-mask and anti-vaccine groupings and taken part in protests against sanitary measures. An increasing trend of sovereign citizens has notably been observed in Australia and in the United Kingdom during the pandemic. Several COVID-related incidents involving local sovereign citizens who refused to follow sanitary measures were also reported in Singapore. In June 2022, researcher Christine Sarteshi reported that the movement was rapidly expanding and could now be found in 26 countries. The movement has no defining text, established doctrine, or centralized leadership. There are, however, common themes generally implying that the legitimate government and legal system have been somehow replaced and that the current authorities are devoid of legitimacy. Taxes and licenses are likewise thought to be illegitimate. A number of leaders, commonly referred to as gurus, develop their own variations. The movement's theories include numerous influences from a variety of sources, some of them decades old, resulting in a narrative of American history that is often confusing and incoherent. Sovereign citizens' legal theories reinterpret the Constitution of the United States through selective reading of law dictionaries, notably an obsolete version of Black's Law Dictionary, state court opinions, or specific capitalization, and incorporate other details from a variety of sources, including the Uniform Commercial Code, the Articles of Confederation, the Magna Carta, the Bible, and foreign treaties. They ignore the second clause of Article 6 of the Constitution, the Supremacy Clause, which establishes the Constitution as the law of the land and the United States Supreme Court as the ultimate authority to interpret it. Most consider that the county sheriff is the most powerful law enforcement officer in the country, with authority superior to that of any federal agent, elected official, or local law enforcement official. Not all sovereign citizens will call themselves as such, and some movement members actually regard the term sovereign citizen as an oxymoron. Sovereign citizens may prefer to label themselves as individuals seeking the truth or living on the land, or use other denominations such as state, national, natural person, constitutionalists, freemen, natural people, living people, or private person. A widespread belief among sovereign citizens is that the state is not an actual government, but a corporation. American movement members consider that the corporation purporting to be the U.S. federal government is illegally controlling the republic via a territorial government in Washington, D.C. Some sovereign citizens also believe that the United States corporation is bankrupt. As a result, the illegitimate U.S. government is said to secretly use its citizens as collateral against foreign debt, effectively enslaving Americans. Sovereign citizens believe that this sale of American citizens takes place at the birth of each American baby through issuing their birth certificate and attributing their Social Security number. Sovereign citizens believe that when the government set up by the Founding Fathers under a common law, legal system was secretly replaced commercial law, substituted for common law. This commercial law is generally understood to be admiralty law, as sovereign citizens consider that the current illegitimate law is based on principles of international commerce. This leads sovereign citizens to believe that U.S. judges and lawyers are actually agents of a foreign power. Sovereign citizens also claim that the appearance of gold fringes on American flags that are displayed in courtrooms is evidence of admiralty law being in effect. Sovereign citizens will therefore challenge the validity of the contemporary legal system and claim to answer only to God's law or to common law, meaning by that the system which supposedly existed before the conspiracy. There is no consensus among sovereign citizens as to when the secret change of political and legal system took place. Some believe it occurred during the Civil War, while others date it to 1933, when the United States abandoned the gold standard, which is often believed to be the cause of the country's bankruptcy. According to one version, the vehicle for the change was the District of Columbia Organic Act of 1871, which sovereign citizens believe created a United States corporation to govern the District of Columbia under commercial code. This form of corporate rule then extended to the entire country. Another theory has it that the country was secretly reorganized as a post office in 1789. Pseudolegal schemes attribute a particular power to the Universal Postal Union and to the use of postage stamps on legal documents. The beliefs that the current government is a corporation and that people are secretly under a form of commercial law leads sovereign citizens to consider that statutory law is a contract binding people to the state. According to this theory, people are tricked into said contract through various things, including social security numbers, fishing licenses, or ZIP codes, and avoiding their use means immunity from government authority. Another common belief among sovereign citizens is that they can opt out of the purported contract, hence making themselves immune from the laws they do not wish to abide by declining to consent. When confronted by police officers or other officials, sovereign citizens will typically attempt to negate their authority by stating, "I do not consent." Many sovereign citizens believe that the Uniform Commercial Code, which provides an interstate standard for such things as property ownership or bank accounts and documents that they believe apply only to their strawman, such as driver's licenses, is a codification of the illegitimate commercial law ruling the United States. Therefore, they consider that exploiting supposed loopholes in the UCC will help them assert their rights or invoke their special privileges and powers as common law citizens. The unpassed Titles of Nobility Amendment has been invoked to challenge the legitimacy of the courts, as lawyers sometimes use the informal title of Esquire. The belief that the current legal system is illegitimate has impelled some sovereign citizens to consider themselves as above the law and to commit actual crime. American sovereign citizens posit that contemporary United States citizenship is somehow defective or fraudulent, and that it curtails citizens' legitimate right Some sovereign citizens also claim that they can become immune to most or all laws of the United States by renouncing citizenship in a federal corporation and declaring only to be a citizen of the state where they reside. This process, which they refer to as expatriation, involves delivering a non-legal document claiming their renunciation of citizenship to any county clerk's office that can be convinced to accept it. In the 1970s, one of the movement's originators, white supremacist ideologue William Potter Gale, identified the 14th Amendment to the United States Constitution as the act that converted sovereign citizens into federal citizens by their agreement to a contract to accept benefits from the federal government. Other commentators have identified other acts, including the Uniform Commercial Code, the Emergency Banking Act, the Zone Improvement Plan, and the alleged suppression of the titles of nobility amendment. Likewise, sovereign citizen leader Richard McDonald claimed that there are two classes of citizens in America. The original citizens of the states, also called state citizens or organic citizens, and U.S. citizens. According to McDonald, U.S. citizens, whom he calls 14th Amendment citizens, have civil rights, legislated to give the freed black slaves after the Civil War rights comparable to the unalienable constitutional rights of white state citizens. The benefits of U.S. citizens are received by consent in exchange for freedom. In this perspective, state citizens must consequently take steps to revoke and rescind their U.S. citizenship and reassert their de jure common law state citizen status. This involves removing oneself from federal jurisdiction and relinquishing any evidence of consent to U.S. citizenship, such as a social security number, driver's license, car registration, use of ZIP codes, marriage license, voter registration, and birth certificate. Also included is the refusal to pay state and federal income taxes because citizens not under U.S. jurisdiction are not required to pay them. Sovereign citizens may claim that their status in the United States is that of non-resident alien. Only resident aliens of the states, not its citizens, are income taxable. Sovereign citizens argue, and as a state citizen landowner, one can bring forward the original land patent and file it with the county for absolute or allodial property rights. Such allodial ownership is held without recognizing any superior to whom any duty is due on account thereof. Black's Law Dictionary. Superiors include those who levy property taxes or who hold mortgages or liens against the property. The concept of 14th Amendment citizens is consistent with the movement's white supremacist origins in that it can cause adherents to believe that African Americans, having only become legal citizens after the Civil War, have far fewer rights than whites, or that only black people have to pay federal taxes and abide by federal laws. On the contrary, Moorish sovereign citizens consider that African Americans constitute an elite class within American society with special rights and privileges that make them immune from federal and state authority. They will commonly adopt Africanized version of their names by adding L or Bey or a combination of the two and associate themselves with a particular Moorish group, claiming that they are not culpable for acts committed under their previous name, and that their affiliation makes them immune from prosecution. The underpinnings of the theories of African American exemption vary. One belief is that the Moors were America's original inhabitants and are therefore entitled to be self-governing. They claim to be descendants of the Moroccan Moors and to be thus subject to the 1786 Moroccan-American Treaty of Friendship, which they believe gives them exemption from American law. A variation of Moorish ideology is found in the Washita Nation, which claims rights through provisions in the Louisiana Purchase Treaty granting privileges to Moors as early colonists and the Moors as early colonists, and the non-existent United Nations Indigenous People Seat 215. Various other sovereign citizen groups claim special status and exemption from their country's laws by purporting to belong to real or imaginary ethnic minority. One recurring idea in sovereign citizen ideology is that individuals have two personas, one of flesh and blood and the other a separate, secret legal personality, commonly called the Strawman. created upon each person's birth that is subject to the government. Sovereign citizens claim that it is possible to dissociate oneself from the strawman through the use of certain procedures, thus becoming free of all debts, liabilities, and legal constraint. Sovereign citizen texts often posit that international bankers are at the source of the conspiracy that replaced the United States' legitimate government and legal system. In the movement's earlier form, these bankers were explicitly stated to be Jews. While this can still be implied in sovereign citizen literature, the movement's original anti-Semitic conspiracy theories were diluted over time. Most contemporary sovereign citizens tend to present greatly simplified versions of these theories without any mentions of Jewish conspiracies and with only vague references to the role of corrupt bankers. The sovereign citizen movement overlaps with the redemption movement, also known as a fourth, after one of its schemes, which claims that a secret bank account is created for every citizen at birth as part of the process used by the U.S. government to sell its citizens into slavery and use them as collateral as a result of the country's secret bankruptcy. Redemption theories assert that the vast sums of money contained by this account can be reclaimed through certain procedures and applied to financial obligations or even criminal charges. Several prominent sovereign citizens have advocated redemption schemes. The belief in a secret bank account is intertwined with the Strawman theory, since this fund is supposedly associated with the strawman. Pseudolegal economic theories also imply various misconceptions about currencies and financial institutions, one being that banks create money from thin air, so a borrower has no obligation to pay them back, and another that money is actually worthless when not backed by gold. Many sovereign citizens do not recognize this currency and demand to receive their money in the form of gold or silver coins. Some sovereign citizens also subscribe to the NASAR-related conspiracy theory, using arguments that rely on exacting definitions and word choice. Sovereign citizens may assert a constitutional right to travel in a conveyance, distinguishing it from driving an automobile in order to justify ignoring requirements for license plates, vehicle registration, insurances, and driver's licenses. The right to travel is claimed based on a variety of passages, some being more commonly used among groups. One common argument from sovereign citizens is that they're traveling and not driving because they're not transporting commercial goods or paying passengers. Other pseudo-legal theories commonly shared by sovereign citizens include that silence means consent for any sort of documents, that any claim or alleged statement of fact placed in a sworn document known in pseudo-legal jargon as an affidavit of truth is proven true unless rebutted, and that there is no crime if there is no injured party. Some sovereign citizens are involved in other forms of conspiracy theories, including QAnon. Certain subgroups within the movement adhere to theories about extraterrestrials and reptilians. One advocate of sovereign citizen fraudulent tax avoidance schemes, C.M. David Morton, was also active as a psychic and ufologist. In Quebec, sovereign citizen ideology has been promoted by anti-vaccine activist and AIDS denialist Ghislaine Langda. In 2022, the Anti-Defamation League reported that sovereign citizen ideology was increasingly seeping into QAnon as the movement's anti-government views were compatible with QAnon's belief in a worldwide cabal and in the illegitimacy of the Biden administration. Several groups, notably that led by Guru David Straight, have been convincing parents whose children were removed from their custody that Child Protective Services are engaged in child trafficking and encouraging them to kidnap their children. Several sovereign citizen gurus have made grandiose claims about the powers supposedly granted to them by their pseudo-legal schemes. One American ideologue and quantum grammar advocate Russell J. Gould claims that having signed a postal receipt in a specific way and filed a document relating to Title IV of the United States Code at a moment when the United States was supposedly bankrupt makes him the Postmaster General and legitimate ruler of the country. Another American guru, Heather Ann Tucci Jarrah, claimed before her sentencing for fraud to have foreclosed and cancelled all banks and governments through a CC filing. Likewise, Ramona Didelot, a Canadian quantum conspiracy theorist, uses sovereign citizen concepts to back her claims of being the rightful Queen of Canada and eventually the Queen of the world. Sovereign citizens may be affiliated to a group within the movement, follow the teachings of a specific guru, or act entirely on their own. By disobeying rules they consider to be illegitimate, they regularly find themselves in conflict with all forms of government institutions, most commonly law enforcement, the judiciary, and the revenue services. One sovereign citizen from Montana, Ernie Wayne Turtle Date, became a local celebrity by engaging in 2013 in a protracted legal battle with authorities over the need to have a fishing license, and then having multiple incidents with law enforcement over this matter or over his lack of a driver's license. Sovereign citizens often use irregular documents and flawed or invented legal arguments as proof of their claims. Pseudolegal documents, including those purporting to assert one's sovereignty, thus making him immune from his country's law, may be sold by sovereign citizen groups for monetary gain. It is common for sovereign citizen gurus to earn money by selling to followers of the movement standard documents such as template filings, scripts to recited court appearances, or other quick-fix solutions to legal problems. Some gurus sell how to manuals explaining the movement's theories and schemes. One such manual is titled "Four Flags Says Your Schwag," the Sovereign Citizen's Handbook, which has been reprinted and updated several times. Sovereign citizens will use an unusual vocabulary and twist the meaning of legal terms, or even commonplace phrases according to their own convenience. This includes avoiding the use of expressions they think would make them enter into a contract with the government. For example, when dealing with the police, sovereign citizens will often avoid saying, "I understand," and will say instead, "I comprehend," as they believe that the word understand acknowledges that one stands under the jurisdiction. Thus, recognizing the police's authority, sovereign citizens' conflicts with authorities have occasionally resulted in violence. Sovereign citizens consistently violate traffic laws by refusing to use driver's licenses and valid license plates and to register or insure their vehicles. Some use homemade license plates and bumper stickers, which can serve the unintended purpose of warning police officers that they are dealing with a sovereign citizen. Most interactions of sovereign citizens with law enforcement actually take place on the road. As a result, the general public is mostly familiar with the movement through online videos of sovereign citizens' confrontations with traffic officers. Many sovereign citizens engage in various forms of tax resistance, causing disputes with government administrations. It is estimated that in the United States, sovereign citizens and other tax protesters have caused about $1 billion in public losses from 1990 to 2013. Sovereign citizens use a variety of fraudulent schemes, including filing false securities to avoid paying taxes, to get refunds from the government, or to eliminate their debts and mortgages. The belief that money is worthless since the abandonment of the gold standard has led sovereign citizens to create fictitious financial instruments. One of the first to use this method in the 1980s was tax protester and songwriter Tupper Saucy, who created check-like instruments which he called public money office certificates. While Saucy issued these certificates primarily as a form of protest, sovereign citizens have been using false promissory notes, bills of exchange, coupons, bonds, or sight drafts to pay taxes, purchase properties, or fight foreclosures. Some gurus have scammed adherents to the movement by selling them such counterfeit instruments. Sovereign citizens may use the ineffective methods advocated by the redemption movement for appropriating the sums from one's purported secret treasury account. Such schemes are sometimes called money for nothing. For example, writing accepted for value or taken for value on bills or collection letters will supposedly cause them to be paid with the Strawman secret fund. The scheme is commonly known as a form Purported methods for claiming a secret fund include filing a UCC-1 financing statement against one strawman after separating from it. Sovereign citizen documents may include unusual formalities such as Latin maxims, thumbprints, or stamps in certain places, as well as unconventional, sometimes incomprehensible legally. Stamps are generally accompanied by signatures with the sovereign citizen's name signed across them, initials or other markings. Signatures and thumbprints are likely to be in red ink or blood, since black and blue inks are believed to indicate corporation. As bonds are canceled using red ink in some U.S. states, sovereign citizens may sign in red ink to signify that they are canceling the bond attached to their birth certificate or to their strawman. Others use red ink because it represents the blood of the flesh and blood person. Other methods to dissociate oneself from the strawman include unusual spelling and writing one's name in a different manner or with punctuation, John of the family Doe instead of John Doe, or John Robert Doe instead of John Robert Doe. Sovereign citizens will often add the Latin phrase sui juris, meaning of one's own right, to their names on legal documents to signify that they are reserving all the rights to which they are entitled as a free person. Postage stamps are supposed to make pseudolegal documents authoritative, but their meaning varies depending on the guru. One version has it that stamps grant sovereignty to pseudolaw affiliates. Their use on documents purportedly makes one a postmaster with equal rights and peer status to nation-states. When signing an official document such as a driver's license, a mortgage document, or a traffic ticket, sovereign citizens will often add under threat, duress, and coercion, or a variation thereof, such as the initials TD, name. That phrase implies that they are not voluntarily signing the document, which purportedly helps them avoid entering into a contract with the illegitimate government and falling under its jurisdiction. Some may write TDC after their ZIP codes. Cases involving sovereign citizens can cause severe problems to law enforcement officers and court officials. Sovereign citizens may challenge laws, rules, or sentences they disagree with by engaging in the practice known as paper terrorism, which involves filing complaints with legal documents that may be bogus or simply MIPU. Minor issues such as traffic violations or disagreements over pet licensing fees may provoke numerous court filings. Courts will then find themselves burdened with having to process hundreds of pages of irregular pseudo-legal documents, causing a strain on their resources. In May 2019, Kim Bandino, a felon residing in Nevada, was found guilty of traffic offenses. He then threatened the judge who had presided over his hearing to file complaints against him and demanded a monetary settlement from him. Bandino was charged with extortion and impersonation of an officer. He then filed numerous motions to delay the proceedings and tried to disqualify almost every judge in the district. Bandino's motions required multiple reviews and countless hours of hearings. As a result, the case had not yet reached a final disposition by March 2022. When involved in court cases, sovereign citizens will generally act as their own lawyers, though on some occasions a sovereign citizen leader may assist them in court. They often use uncommon or downright disconcerting pseudo-legal tactics. People and groups linked to the movement have been using a constructive language created by American theorist David Wynn Miller, who asserted that this unorthodox version of the English language, variously called parse, syntax, grammar, correct language, truth language, or quantum grammar, guarantees success in legal proceedings where it constitutes the only correct form of communication, as they regard themselves as bound only by their own interpretation of common law. Sovereign citizens have been setting up militias of self-appointed sheriffs, as well as common law courts, to handle matters regarding movement members. These courts, which are devoid of legal authority, are frequently used to formalize the declarations of sovereignty of movement members in a process often known as asseveration. Besides paper terrorism, sovereign citizens have used various techniques of intimidation and harassment to achieve their goals. One method of retaliation used by sovereign citizens against public officials or against other real or perceived enemies is the filing of false lien Anyone can file a notice of lien against property such as real estate, vehicles, or other assets of another under the Uniform Commercial Code and other laws. In most states of the United States, the validity of liens is not investigated or inquired into at the time of filing. Notices of liens, whether legally valid or not, are a cloud on the title of the property and may affect the property owner's credit rating, ability to obtain home equity loans, refinance the property, or take other action with regards to the property. Clearing up fraudulent notices of liens may be expensive and time-consuming. Illegitimate sovereign citizen common law courts are also used to put enemies on trial. On occasion, public officials have been tried in absentia by sovereign citizens and sentenced to death for treason. Another tactic used by sovereign citizens involves false arbitration entities operated by movement members that will issue unilaterally on behalf of their clients rulings ordering the client's creditors or other victims to pay large sums of money in damages. In 2022, the Anti-Defamation League reported that although this particular tactic seems to have appeared around 2014, its use had intensified since 2019. According to the ADLL's report, these sham rulings are designed, besides targeting specific victims, to clog the court system that sovereign citizens consider to be illegitimate. Some sovereign citizens have advocated and practiced adverse possession of property. Notably, Maori sovereigns have cited reparations as a justification for squatting homes and claiming other people's properties as their own, even though they also targeted the possessions of other African Americans. In the United States, some people involved in First Amendment audits have been identified as sovereign citizens by authority. Sovereign citizens' tactics often succeed in delaying legal proceedings and may occasionally confuse or exhaust public officials. However, their arguments are never upheld in court. Their claims have been consistently rejected by courts in various countries, including the United States, Canada, Australia, and New Zealand. Mark Pitcavage, a researcher working for the Anti-Defamation League Center on Extremism, has summed up sovereign citizen ideology as magical thinking. One state representative from New Hampshire, Richard Marple, repeatedly tried to introduce legislation that would recognize sovereign citizen ideas, though without success. One crucial flaw of pseudolegal theories in general is that the common law they cite is based not on historical precedent, but instead on an erroneous perception of traditional English law. In 2012, the Court of Queen's Bench of Alberta's Mead's decision pertaining to a contentious divorce case in which the husband used Freeman on the land argument compiled a decade of Canadian jurisprudence and American academic research about pseudo-law. It went much further than the matters of the case by covering various arguments and tactics commonly used by the freemen on the land, redemption, and sovereign citizen movements and refuting them in detail. Mead's, written by Associate Chief Justice John D. Rooker, has since been used as case law by courts in Canada and in other Commonwealth countries. Pseudo-legal documents and arguments claiming that one is personally immune from jurisdiction or should not be paying taxes have never been accepted by any court. In 1990, after Andrew Schneider was convicted and sentenced to 5 years in prison for making a threat by mail, he argued that he was a free sovereign citizen and therefore was not subject to the jurisdiction of the federal court. That argument was rejected by the United States Court of Appeals for the Seventh Circuit as having no conceivable validity in American law. The belief that legal obligations are contracts that can be opted out fails to acknowledge that government and court authority is not a product of one's consent, and that the relationship between the state and an individual is not based on a contract. The Canadian decision Meads v. Mead. Meads refuted the theory that laws are contracts, commenting that a claim that the relationship between an individual and the state is always one of contract is clearly incorrect. Aspects of that relationship may flow from mutual contract. For example, a person or corporation may be hired by the government to perform a task, such as road maintenance. But the state has the right to engage in unilateral action, subject to the charter and the allocation and delegation of government authority. The conception that one can avoid paying taxes in the country he physically resides in by renouncing or challenging the validity of his citizenship and by claiming to be a non-resident alien is legally baseless. The Internal Revenue Service has refuted in detail frivolous tax arguments such as this and the idea that filing tax returns and paying federal income tax are voluntary. In a criminal case in 2013, the United States District Court for the Western District of Washington noted, defendant Kenneth Wayne Leeming is apparently a member of a group loosely styled sovereign citizens. The court has deduced this from a number of defendants' peculiar habits. First, like Mr. Leeming, sovereign citizens are fascinated by capitalization. They appear to believe that capitalizing names have some sort of legal effect. For example, defendant writes that the Registeradfacts appearing in the above paragraph evidence the uncontroverted and uncontrovertible FETS, FDSLASEI, operated in the names OPWASEEETUSES, non-pro-tunc by public policy, you say 103 death. That's mandatory judge, not at 2. He appears to believe that by capitalizing United States, he is referring to a different entity than the federal government. For better or for worse, it's the same country. Second, sovereign citizens like Mr. Leeming love grandiose legalese, COMESNOW, Kenneth Wayne, born free to the family Leeming, date of birth redacted, constituent to the people of the state of Washington, constituent 1878, and admitted to the Union 22 February 1889 by Act of Congress, a man state of body competent to be a witness and having first-hand knowledge of the FACTS depths mandatory judge, not at 1. Third, defendant evinces, like all sovereign citizens, a belief that the federal government is not real and that he does not have to follow the law. Thus, defendant argues that as a result of the EREGISTERADFATTETS, the states of body, persons, actors, and other parties perpetuating the above captioned transactions, i.e., the court and prosecutors are engaged in acts of corruption. Yes, mandatory judge, not at 2. The court, therefore, feels some measure of responsibility to inform defendant that all the fancy legal-sounding things he has read on the internet are make-believe. Defendant can call himself a public minister and private attorney general. He may file mandatory judicial notices. Citing all his favorite websites, he can even address mail to the Washington Republic. But at the end of the day, while sovereign citizens and defendants cite things like universal law ordinances, they are subject to both state and federal laws, just like everyone else. Leeming was found guilty of 3 counts of retaliating against a federal judge or law enforcement officer by a false claim, 1 count of concealing a person from arrest, and 1 count of being a felon in possession of a firearm. On May 24, 2013, Leeming was sentenced to 8 years in federal prison. In 2017, former Subway spokesman Jared Fogle, with the help of another inmate, filed 2 motions aimed at overturning his convictions on child sex tourism and child pornography charges on the basis of his status as a sovereign citizen on whom the court had no jurisdiction. The court dismissed the motions, commenting that Fogle's arguments had no conceivable validity in American law, and that the Seventh Circuit has rejected theories of individual sovereignty, immunity from prosecution, and their ilk. The sovereign citizen concept that courts in the United States are secretly admiralty courts and thus have no jurisdiction over people has been repeatedly dismissed as frivolous Author Richard Abanez considers that sovereign citizens fail to sufficiently examine the context of the case laws they cite and ignore adverse evidence such as Federalist Note 15, wherein Alexander Hamilton expressed the view that the Constitution placed everyone personally under federal authority. The Strawman theory has been repeatedly dismissed by courts. In 2021, the District Court of Queensland dismissed an application that relied on this theory, commenting that the so-called strawman argument may properly be described as nonsense or gobbledygook. The FBI considers anyone promoting it a likely fraudster. Meads v. Meads addressed the strawman theory, stating that double split person schemes have no legal effect. These schemes have no basis in law. There is only one legal identity that attaches to a person. If a person wishes to a person, if a person wishes to add a legal layer to themselves, then a corporation is the proper approach. The theory of a secret fund associated with the strawman is considered a scam. The schemes advocated by the redemption movement amount to fraud. Redemption methods, such as accepted for value, are based on a misinterpretation of the Uniform Commercial Code and have no effect. Creating and selling fictitious financial instruments is likewise a scam. People who purchase sovereign citizen instruments purported to help them pay off their debts or avoid foreclosures have worsened their situation by doing so. Sovereign citizens' argument that they do not need driver's licenses, license plates, and vehicle insurances has never been upheld in court. One common response to this claim from U.S. law enforcement is that while anyone is free to travel by foot, by bike, or even by horse, operating a motor vehicle is a complex activity that requires training and licensure. Several United States Supreme Court rulings state that driver's licenses and traffic regulations are necessary for public safety. The claim that the District of Columbia Organic Act of 1870 turned the United States into a business corporation is based on a misunderstanding of the term municipal corporation used in the act, which referred to the District of Columbia and not to the entire country, and on a misinterpretation of a provision in Title 28 of the United States Code, which includes a definition of the United States as a federal corporation, meaning a group authorized to legally act as a single entity and not a business corporation. The theories that silence means consent and that an unrebutted affidavit stands as truth are based on misinterpretations of the legal maxim, he who does not deny admits. The idea that there is no crime if there is no injured party is based on a misinterpretation of tort law and fails to recognize the existence of different levels of legal violations. Filing fraudulent notices of liens or documents is a crime in the United States. American courts have routinely dismissed documents written in David Wynn Miller's sparse syntax, grammar, quantum grammar language, calling them unintelligible. Canadian Judge John D. Rook commented in his Meads v. Meads decision that Miller's bizarre form of legal grammar is not merely incomprehensible in Canada, but equally so in any other jurisdiction. The Universal Postal Union, which is often invoked as a supranational authority in sovereign citizen schemes, has officially denied that it has the authority to confer official recognition upon sovereign citizens or to grant some kind of formal status to such individuals, also specifying that the use of postage stamps on legal documents does not create an opportunity or obligation for the UFU to become involved in those matters. Sovereign citizens' common law court are devoid of any legal standing. Some may be simply ignored by authorities. In 2015, sovereign citizen guru Anna Maria Riesinger, aka Anna von Rietz, the self-proclaimed judge of a common law court in Alaska, published a letter calling for federal agents to arrest President Barack Obama, the entire Congress, and the Secretary of the Treasury, causing a minor internet rumor. Snopes debunked her claim by establishing that von Rietz was not a real judge, and that her order, therefore, had no force. However, depending on the nature and severity of their actions, sovereign citizen courts may be disbanded and their leaders prosecuted. In 2018, upon sentencing sovereign citizen judges, Bruce Duchette to 38 years in prison, Colorado's 18th Judicial District likened his network of common law courts to a racketeering enterprise equivalent to organized crime. There is some crossover between the two groups calling themselves freemen and sovereign citizens, as well as various others sharing similar beliefs, which may be loosely defined as seeing the state as a corporation with no authority over free citizens. With the advent of the internet and continuing during the 21st century, people throughout the Anglosphere who share the core beliefs of these movements have been able to connect and share their ideas. While arguments specific to the history and laws of the United States are not used, except inadvertently, by litigants who use poorly adapted as material, many concepts have been incorporated or adopted by individuals and groups in English-speaking Commonwealth countries. In Canada, which has its own tradition of tax protesters, fiscal misconceptions of American origin were gradually introduced during the 1980s and 1990s. Around 1990s and 1999, 2000 sovereign citizen and redemption concepts were introduced into Canada by Eldon Warman, who adapted them to a Commonwealth context. These ideas were further adapted in Canada by the Freemen on the Land movement, which espouses an ideology broadly similar to that of the sovereign citizen movement, but is aimed at a less conservative audience. Canadian-style Freemen of the Land ideas were later imported into other Commonwealth countries, but American-style sovereign citizen ideology has also reached these regions of the world. As of the 2010s, there are people identifying as sovereign citizens in Canada, Australia, New Zealand, the United Kingdom, the Republic of Ireland, and South Africa. Sovereign citizens from the U.S. have gone on speaking tours to New Zealand and Australia, appealing to struggling farmers, and there are internet presences in both countries. Whilst the more Canada-specific Freemen on the Land movement has declined since the early 2010s, the Canadian sovereign citizen movement has gained traction during the same period. Canada had an estimated 30,000 sovereign citizens in 2015, many associating with the Freemen on the Land movement as well. There can be confusion between the two populations. Legal scholar Donald J. Nidalitsky makes a distinction between the Canadian sovereign citizen and Freemen on the Land movements, in that Freemen on the Land, while ideologically heterogeneous, tend to be politically more left-leaning than sovereign citizens. The 2012 Meads ruling examined almost 150 cases involving pseudolegal and sovereign citizen or freemen of the land tactics, grouping them and characterizing them as organized pseudolegal commercial argument. Australia, which has its own tradition of pseudolegal, imported sovereign citizen ideas in the 1990s, even before the movement's 2000s resurgence. It later imported the more Commonwealth-specific Freemen on the Land movement. There is some crossover between Australian Freemen on the Land, local sovereign citizens groups, and some others. The core concept has been tested by several court cases, none successful for the Freemen. In 2011, climate denier and political activist Malcolm Roberts, later elected senator for Pauline Hanson's One Nation Party, wrote a letter to then Prime Minister Julia Gillard filled with characteristic sovereign citizen ideas and vocabulary. Although he denied that he was a sovereign citizen, from the 2010s, there has been a growing number of freemen targeting Indigenous Australians, with groups using names like Tribal Sovereign Parliament of Gondwana Land, the original Sovereign Tribal Federation, OSSBAF, and the original Sovereign Confederation, OSTF. Founder Mark McMurtry, an Aboriginal Australian man, has produced YouTube videos speaking about common law, which incorporate freemen belief, appealing to other Aboriginal people by partly identifying with the land rights movement. McMurtry played on their feelings of alienation and lack of trust in the systems which had not served Indigenous people. Well, in 2015, the New South Wales Police Force identified sovereign citizens as a potential terrorist threat, estimating that there were about 300 sovereign citizens in the state at the time. Freemen's sovereign citizen ideas have been promoted on the internet by various Australian groups such as United Rights Australia. Who are Australia? The COVID-19 pandemic in Australia has accelerated the spread of the movement. Numerous incidents with law enforcement have since been reported in Australia, some of them violent, such as the 2022 Whyambilla shooting. Sovereign citizen ideology reached the United Kingdom around 2010. British sovereign citizens have helped spread COVID vaccine misinformation as well as various conspiracy theories, including 9/11 theories and one about the Queen having been replaced by a satanic cabal, and tried to set up their own cryptocurrency. The Common Law Court website, one of the main UK sovereign citizen resources, has for a time supported an impostor who claimed to be the rightful heir to the British throne. The Reichsbürger movement, Reich Citizen movement, in Germany originated around 1985 and had approximately 19,000 members in 2019, more concentrated in the south and east. The originator claimed to have been appointed head of the post-World War Reich, but other leaders claim imperial authority. The movement consists of different, usually small groups. Some groups have issued passports and identification cards. The Reichsbürger movement claims that modern-day Germany is not a sovereign state, but a corporation created by allied nations after World War II. They also expressed their hope that Donald Trump would lead an army to restore the Reich. According to the German Domestic Intelligence Service, only a small number of groups in the Reich Citizen movement fall into the far-right spectrum. Rather, the common denominator is the rejection of the Federal Republic as a legal entity. The Reichsbürger movement has used language and techniques from the One People's Public Trust, an American sovereign citizen group operated by Guru Heather and Tulsi Gabbard. On December 7, 2022, 25 people connected to the Reichsbürger movement were arrested in a nationwide raid by German police forces for their involvement in a suspected terrorist plot against the German government and institutions. Austria, the group Staatenbund Österreich as Austrian Commonwealth, in addition to issuing its own passports and license plates, had a written constitution. The group, established in November 2015, also used language from the One People's Public Trust. In 2019, its leader was sentenced to 14 years in jail after trying to order the army to overthrow the government and requesting foreign assistance from Vladimir Putin. Other members received lesser sentences. As of the 2010s, incidents involving sovereign citizens have been reported in Italy, with various people purporting to opt out of Italian citizenship through non-legal procedures and make themselves immune from Italian law. Members of one group attempt to do so by declaring themselves citizens of the sovereign kingdom of Gaia, Regno Sovrano di Gaia, while others refer to themselves as the people of Mother Earth, Popolo della Terra Madre. A Russian movement of conspiracy theorists, known among other names as the Union of Slavic Forces of Russia, Soyuz Slavyanskych Sil Rusi, or more informally as Soviet citizens, holds that the Soviet Union still exists de jure, and that the current Russian government and legislation are thus illegitimate. One of its beliefs is that the government of the Russian Federation is an offshore company through which the United States illegally controls the country. In 2021, a New Age-oriented French group of conspiracy theorists called One Nation became known to the public for their involvement in the kidnapping of a child. Later that year, they attempted to purchase a property in the rural department of Locke, purportedly to create a center for the art and a research laboratory. The One Nation movement holds beliefs similar to those of American sovereign citizens and denies the legitimacy of the French state. They also share beliefs with Quan. The name sovereign citizen is sometimes translated in French as êtres souverains, sovereign beings, or êtres aveugles, awakened beings. People affiliated with One Nation are also active in Belgium. In February 2022, the group's French spokeswoman was sentenced to 6 months in prison for multiple traffic violations. She was arrested and incarcerated in September of the same year.